And he says, "This is all I got." I go, "I hope that works for you. Who's the attorney?" And he points in this Memphis attorney, banker type attorney. I said, good luck with that one. And so I saw him about an hour later in the Chancery Court building. I said, "How'd the catfish charge go?" He says, "We settled the case." I said, "Alone?" He said, "Yeah, we settled the case." He said, "But, you know, with me, I couldn't have done that with a straight face. You know? For with Gaines, you know, he good old boyed it and got the deal for the client. So it's bankruptcy is bankruptcy is very pragmatic. It's very unemotional. It's let's make a deal, and it's code-driven. It's in our country is driven by credit, right? And credit gives opportunities, and credit has downsides too. Some people, I mean, some of you might have student loans that you're going to graduate with. Credit can create interest income for elderly. I do that. It can finance your education, a car, or a house, or a business. My law firm started out financing a business. We started in '07, you know, separately in the recession. Kind of a scary time. Well, I did it wrong. Too much credit. Can I?
Yes, I can fix that for you.
All right. Operator error.
You just use this one. This is the pointer.
Okay. Yeah. We didn't have PCs when I started practicing. All right. Too much credit, as you know, can overheat the economy, cause inflation, problems with how are you going to pay your student loans with the income you can derive. Too much debt can cause a bankruptcy. Even Birmingham is about to file bankruptcy. And one issue that I'm involved in, I represent creditors, and he's always trying to get 7% interest.
At 5.5.
Yeah. See, he's working on it. And so my client is always trying to get a higher rate of interest. Why? Well, if they're in bankruptcy, I say you're already got a credit risk. You're in bankruptcy, so the interest that you pay is supposed to be tied to the risk involved, but that's not always the case. Indigent people with less education tend to pay more in interest, and bankruptcy tends to protect them. Predatory lending, it can cause debt burdens. You've heard these cash advance places. They're charging hundreds of percent of interest, and then people can be saddled with more debt than they could possibly pay back.
If I could interject a little thing here, just to, as I understand, what we're supposed to do is try to give you an idea why bankruptcy would be beneficial to you, no matter what area you're in. If you're looking at predatory lending litigation, a great place to do that is in the bankruptcy court. My partner and I, before a lady named Katrina came through and suggested that my partner moved to Texas and that I moved to Oxford, and our third partner would get a job as a Chapter 13 trustee in North Louisiana, and all dissipate from the city of Biloxi. But we were handling and settled a case with a major national lender who had also been sued by every attorney general in the country. Okay. And the attorney generals, like in Mississippi, settled. I think each person got $3,000, and I can't mention the defendant or anything like that, or exactly what we got because of confidentiality agreement signed. But let's put it this way: my partner and I, in the multiple cases we had, which was only 30, both made over 6 figures off of this. So you can imagine if we got that kind of money, how much benefit my clients got out of it. But we used the bankruptcy process to stop the foreclosures, to stop the things that we had while we had the litigation going on, and managed to do that. So predatory lending is one place where bankruptcy and knowledge about bankruptcy, even if you don't do that, and knowing when to associate a bankruptcy attorney to help you would be one reason for taking this class. Go ahead.
Okay. And the bankruptcy evolved, and it's as a response to, it's a very practical response. Those who have some knowledge of the Bible, you know, there was the time of Jubilee where you would be free of debts, and every people were enslaved if they couldn't pay their debts. Back then, you enslaved people were. In fact, there's in the Far East, there's still issues about enslavement of family members for people who can't pay their debts. You know, we agree in this society that's not a good thing. Debtors were imprisoned. Up to, in this county, they had a poorhouse. And some of our founding two signers of the Declaration of Independence, James Wilson and Robert Morris. Robert Morris helped finance our revolution. We're in prison, in debtor's prison. R.E. Lee's father, Light Horse Harry, was in prison, in debtor's prison. And that was one of his, it always scarred him the rest of his life. Another, the author of the Declaration of Independence, Thomas Jefferson, died pretty broke as well. Debtors were housed in poorhouses in the 1900s, so if we had no solution for it, they would go, that was south of town, near Water Valley, where people who couldn't pay their bills and their families were housed in a poorhouse, and they raised their own garden. If you've seen Oliver Twist and those types of movies, Dickens, you know, decried people being, and what are you going to do if you're imprisoned for debt, right? Well, how are you going to get, you know, you got to pay for the prison. You're hoping your family will pay out. Now there is still, you can be in prison in the United States for not paying a debt. Child support. You know, a chancellor can put you in for that. All right. Why you should know bankruptcy if you don't intend to. One of the things is, the reason I got into bankruptcy in the first firm I started practicing is nobody else wanted to do it, right? You know, everything goes. But the great thing about it is, it was an area where I could get into the courtroom quick. And when I said bankruptcy, everybody else said, I was in a litigation firm, eyes crossed. I said, I don't know, okay, you handle that, right? And it's actually, it's more, if I get into bankruptcy court, I have actually more control over the situation and the debtor than I would otherwise. Certain things you need to know. If you're the divorce attorney, child support and property settlements are treated differently.
Yeah, in that particular instance, the biggest thing I see is somebody puts in a divorce decree that this debt shall not be discharged in bankruptcy. Well, if they could do that, and that's all it took, then you would have it in every type of case that there ever was, or you'd have it in every agreement. Oh, you can't discharge that in bankruptcy. And of course, the clients will come to and say, oh, well, I know I can't do that because it says I can't. And it's kind of like skate at your own risk, you know. Yeah, you skate at your own risk, but if they rent to some drunk that runs over you, you can still sue them and get a lot of money. It doesn't matter what it says. So understanding what you really need to do as a divorce attorney is make sure that the agreement that you work out is something that would hold up that this debt is a what we call a domestic support obligation, child support, alimony. It doesn't have to be that. It could be payment for the car. It could be payment of credit cards if the decree says, and I've seen this, that child support shall be there shall be no child support for the first 3 years, and during that time, the debtor, the husband, shall pay all the credit card debt that the parties are jointly liable on in lieu of support. So later he comes in and he tries to discharge that. Well, he can discharge his obligation to Chase Visa, but he can't discharge his obligation now to his ex-wife because that was in the nature of support. And the Fifth Circuit has a series of tests that you look at: length of the marriage, income earning capacity of the parties, other provisions for support. It's not exactly what the agreement says, it's what the real intent was. And so you got to understand that as a divorce lawyer. So that's, again, if you're not why taking bankruptcy, I think would benefit you even if you never do bankruptcy.
Or in my example, I garnished the wages of a pro football player who had played at Ole Miss, who didn't want to support his child because it was his talent that got in there. And I started garnishing his wages, and he filed bankruptcy. And I said, oh, that's very nice. I just lifted the stay, and I said, thank you very much. Now you're going to support that child. And his agent said, well, I guess I need to do that after all. So.
Yeah, but the bankruptcy at least helped by freeing up enough income so he could afford his support and still will survive. So. Yeah.
Also, if you're in business, certain lease, for instance, if you're in business you can pick and choose which contracts you want if you filed a Chapter 11, which you want to keep going, to make the company keep going, and which ones that you don't want to. So you can have a bunch of contracts that may or may not be affected.
Back to, in talking about business and how bankruptcy can relate to that, and where I've seen mistakes that lawyers make that didn't understand bankruptcy, is number one, I've seen them put a startup company, and everybody knows that 50% of all businesses fail, right? In the first, I forget how many years, but it's not very many. And this is a startup company with a guy that doesn't have a pot to piss in, okay? And they form an LLC to protect his assets. Well, he doesn't have any assets to protect except maybe his equity in his home, which is $10,000 or $20,000, and you got a $75,000 homestead exemption. He's got a car that's like 8 years old and has 138,000 miles on it. So he doesn't need anything to protect anything, and he doesn't even have any employees. The only employee of the company is him. Well, whose liability is he going to limit himself to? The person driving that car that runs over somebody is responsible. You've all, I guess that far enough, if you had torts. And his employer is responsible. The only employee the company has is him. So he doesn't get any relief there. Every bank, 90% of the suppliers are going to make him guarantee the debt anyway. So he got no real relief for him, but he created an entity that can't file a Chapter 13. Now, Chapter 13 around here costs about $3,000. A Chapter 11, I want $20,000 to $30,000 as a retainer just to get started. So which does this guy need if he needs a bankruptcy to reorganize? He needs a 13, but he's got an LLC or a corporation that owns all this stuff, and he can't file a 13. The corporation can't. And so he can't get the relief he needs, so everything goes under. So sometimes people just don't think. They think about what's going to happen if this guy does well, but they forget what happens if this guy doesn't do well. And that's just an example of knowing why bankruptcy, what people could do in a bankruptcy and why you'd need that. A couple other things on that I've seen and mistakes made by lawyers. In a bankruptcy, you can avoid judicial liens, like a judgment lien, okay, if it's on homestead property, okay? So that when a debtor comes out of a 7, 13, or 11, whatever, that house now is free and clear of that lien for the future. You can't avoid statutory liens like a materialman's lien, okay, or a contractor's lien if you've had that. I've seen people sue to enforce a contractor's lien, and over a period of time to try to get it resolved, they finally settled with the attorney that's handling it, and they were so excited that they got it settled, they just took a judgment. They didn't enforce the statutory lien, and so now the guy's trying to settle to get him to cut down on whatever it is, at least cut the interest out, and with the guy that he was talking to, he couldn't get any relief. He called me. Soon as they got the letter or the phone call from me, the first thing they thought about is, I have malpracticed. And we got a great settlement. The guy thinks I was, the greatest lawyer since sliced bread, when in reality, the guy that really won it for him was the guy that fought it for 2 or 3 years and got him so frustrated that by the time they took the judgment, they forgot what they were suing on and they just took a plain judgment. So again, if the lawyer doesn't always think about, what about when I settle this, when I do this, when I enter this order, what happens if the guy files bankruptcy? That's always should be in somebody's thoughts and that. One more is
Can I
time.
throw something in?
Yeah.
Representing creditors, I deal with novice attorneys that are not aware of bankruptcy, and they'll have a fraud case. And they'll maybe, if they have a fraud case, a lot of times somebody will be defaulted. And they'll just get a judgment that says default judgment. Well, in bankruptcy, you have an advantage of having a lower standard of proof in bankruptcy preponderance as opposed to clear and convincing. But you also have a bunch of issues that are not dischargeable. So somebody filing bankruptcy is not necessarily discharged from that debt if, for instance, they committed fraud. But you have to make specific findings. If you don't make specific findings, then you have to litigate the whole issue again in the bankruptcy court, right? And so I spend time fixing what could have been done easily in the bankruptcy court. And when I do get a judgment of default on fraud, I make the specific findings, referring to 523 of the bankruptcy code that says what is and is not dischargeable. And the bankruptcy judge will rely on that, right? And so I won't have to go to court again, so if I'm a litigant, and get specific findings on a judgment. Go ahead.
One more in related to, this is kind of land law instead of business law, but the prescriptions, which is what you call it in Louisiana, and I'll tell you a little bit later, I'll tell you about my friends Boudreaux and Thibodeau and how they think, what they think about bankruptcy, but not right now. But anyway, and over there they
He's
call
from
it
the
prescriptions,
coast, he can't
as
help it.
opposed to statute of limitations. But there's a provision in the code that talks about a statute of limitations that hadn't run during the bankruptcy, that you got a certain amount of time after you come out of bankruptcy to file that lawsuit. It's only like 30 days. When it comes to a judgment lien, the way our law is drafted, there's a tacking deal, and that is if you had 3 years of that judgment being enrolled before the bankruptcy's filed, and now they're in bankruptcy for 1.5 years, and they come out, then they've still got another 4 years before that judgment before they have to re-enroll that judgment. Well, a lot of times land lawyers, they go back and they look at 7 years and they don't think anything about that, but you really need to know, were they in bankruptcy? Because with the judgment rolls and that time period, generally the judgment creditor is not going to realize it. It may never come back to haunt you, but it could. So that's another reason you could use bankruptcy.
And also, if you're a litigator and somebody's filed bankruptcy and you keep on going, he's going to set you up to get it. And for example, I had a client had a little company in a small county south of here where the county's sheriff and justice court judge were a little too connected with the guy on the other side. And there was a 11:30 at night temporary restraining order shutting the plant down, putting an arrest warrant out for my clients who owned the company because the county was too small for the two of them. And they came dragging in my office. And so we put them in bankruptcy and got the home cooking judge out of it and got Judge Houston. And they still tried to arrest my clients. I got them in contempt of federal court, and they started behaving a little better. And then got rid of that frivolous case and got the company out of bankruptcy. Another example, I was involved in the Dow Corning case, the breast implant. We represented doctors all over the state of Mississippi.
I represented the ladies that had the implants.
They didn't necessarily connect the two, I don't know. But anyway, one of the strategies for the plaintiff's bar was to inundate Dow Corning with lawsuits all over the country where they couldn't defend them, right? And there were thousands and thousands of lawsuits. And they sued the doctors simply to get local jurisdiction, to defeat diversity, right?
Right.
And so what happened is Dow Corning filed bankruptcy and got control of those lawsuits and got a settlement process where the claims were adjudicated. Otherwise, you would have a very few people, the first to the courthouse, getting large large judgments and then not the rest. So corporations can protect itself. American Airlines, another example, renegotiated with their unions to survive the company. So
That's what he was talking about earlier, about being able to reject contracts in a bankruptcy. In Chapter 11, for example, Kmart was able to get rid of all their stores that weren't profitable and downsize because a country boy from Arkansas had really blown them away, by the name of Sam. But bankruptcy can be real helpful in a lot of those areas. For example, like he said, the clients that we had, between my partner and I, we had like 70, I think, breast implant cases. And the clients that we had that just had Dow Corning got either $1,000, $10,000, and about that, very small amounts. Some of the companies that didn't go under, of course, Dow Corning was involved in every single case. Okay, not just so if you had another defendant, you had them and Dow, and so they were really inundated by these. It was gonna, it could have broke, and that's the reason obviously they went into 11. But the kind of aside about that, the interesting part about that was that Dow had paid a large donation to Harvard Medical School to do a study on breast implants and silicone. And interestingly enough, after studying all the nurses that had had breast implants and those that didn't, that had gone through Harvard Medical School, and narrowing it down until they had a window of about a year and a half with 5 nurses, they came up with a study that showed that silicone had no effect on these people. And I know it had nothing to do with the millions of dollars in money that Harvard Med School got from Dow Corning to do that, but somehow that worked out. Fortunately, one defendant, we had when I say we, a lawyer out of Texas that we associated and worked with, had a memo that they found supposedly in a garbage can outside the building after the depositions when he took his paralegal and put her in, and to go through and fill their car full of papers. And this memo said, from the guy doing the study on the beagles, dogs, okay, to the head of this particular company, Surgitech, the beagles are dying. What are we going to do? Memo comes back from the head of Surgitech, or the person in her Surgitech handling this: kill all the beagles. Beagles destroy all the evidence. And that one company had to pay real money. And fortunately, out of my share, my partner and I were partners when we started this, and we each kept our own cases. Out of my 30 cases, about 23 of them had Surgitech. I just got lucky. And she only had about maybe 13 out of hers had Surgitech. But instead of getting $5,000, $10,000, or $20,000 in the national settlement, we basically got 2 and 3 times that. Some of my clients were getting $100,000, $125,000 because that's the only people they could use that memo against. They couldn't use it against any of the other defendants. And they weren't inundated by so much that they needed the bankruptcy process. So
I represent the doctors. And actually they got out because they were, pragmatically they didn't have to punish, they were after Dow Corning.
yeah, we really didn't want the doctors. We just wanted to try it in Mississippi.
And the thing about it is that they pulled us up in Michigan, because there's multi-jurisdiction. So.
But how that ties to bankruptcy is you get lots of clients if you're a debtor's lawyer. And when these mass torts come along, this was a natural client base to be able to not have to do advertising, but just send letters to all your clients, and then you build up a large caseload in those areas. So.
All right. Also, another thing is, if you're representing a couple of things, if you're representing a creditor of a business, there's things called preferences. If one creditor is favored over another, there's a 90-day look-back period, and if it's not a goods for exchange, then they can get some of that money clawed back to from the trustee in bankruptcy. And your client can be sued if the bankruptcy is in San Francisco or wherever, and they say, You mean I gotta pay some of that money back? Some of it, yes. So if they're not keeping current for goods, you need to know that if you're a corporate attorney and your client is shipping goods on credit. Finally, I have a case involving an estate where the first question they ask you in bankruptcy is, are you going to receive anything from an estate? Where I represent one of the heirs, and I said, well, I understand that's a questionable will that you want to probate. You ain't going to get anything anyway from this estate, even if you file bankruptcy. The trustee in bankruptcy was going to get the money, and that's going to be distributed to the creditors. Wouldn't you rather your sister get some of those assets instead of the bank? And I know the bank's number, so anyway. So there's leverage that you can use if you have knowledge of bankruptcy. Knowledge is leverage in practicing law.
I think there's one more thing I'd like to talk about before we leave that last page. It's not on our list up there, and that is transfer of assets. If you've had, I don't know which course this would come under, but if you under Mississippi, transfer of assets with the intent to defraud your creditors can be set aside with a 3-year statute of limitations, but you do have to provide intent. Bankruptcy law will teach you that in bankruptcy, all you got to be able to prove is that the person that transferred that asset transferred it within the last 2 years. This is under Section 548, which is the fraudulent transfer provision. It doesn't have to pay any fraudulent intent, just less than value. And so you can use that sometimes to put somebody in involuntary bankruptcy if you're a creditor and you represent a creditor and you know that they've done this, and it's going to be hard to prove intent, but you're in that 2-year window. If you can get enough people to meet the requirements to go with you and put them in involuntary bankruptcy, then the trustee can set that aside easily just by showing he transferred the asset, got this amount, assets worth this amount, comes back, and then the money can be divided up among the creditors.
Well, sometimes you don't even have to prove intent. I won a non-discharge case where this business, the guy wouldn't let us have access to his computer. And
yes,
he wouldn't let us have access so we could establish. In bankruptcy, you have to disclose all your financial information. So it can be a great investigation tool if you have a party in bankruptcy, because they can either disclose it, or if they didn't and you got the bank records, well, they just committed a federal felony, right? So you can get them on that. But one way I got is this guy wouldn't produce it, and the other litigator said, let's pay $3,000 to a computer guy to download that hard drive. I go, not so fast. There's a section 727 of the Bankruptcy Code. If you aren't forthcoming or don't maintain your records adequately, that's a general discharge, meaning all this guy's debts, instead of just the one he owed my client, in 7 figures, over millions, were not discharged because he wouldn't buy a computer program so we could access his books. Now, it might have been he didn't want us to see where he was paying his 12-year-old daughter $15,000 a year instead of my client, but that's something altogether different.
He's exactly right. That 727, it says keep records is the way it says, failure to keep. I had a lawyer on the other side trying to suggest that because my client just kept his records in a box with loose bills, just a local little contractor that doesn't have a computer program, that he wasn't following that code. I took his bluff and said, well, we'll go let Judge Houston decide that, and they didn't do it because I think he kept his records. He just didn't keep them very organized, and they were welcome to look in that box if they wanted it. But it's if you destroy records or you keep in that sense, try to hide or keep somebody from finding out the information that you already had or that you'd maintained, that's where the real problem is.
So it involved, discovery and litigation.
Yeah.
You can. Let's get on to the bankruptcy check. Go ahead.
One last thing on the transfers and mistakes that I've seen made. I've seen time and time again a lawyer that didn't understand bankruptcy tell his client or her client to transfer their home to another person to keep creditors from being able to get that home. Well, if the bankruptcy's filed, the trustee gets that home back now, and the debtor claim that as exempt anymore, even if he's still living there. And the worst case I ever saw was after I moved up here, after Katrina, where a lawyer over in somewhere west of here, I don't remember, but it's Batesville or Clarksdale or somewhere, had told the guy to transfer it to his minor child. Well, we've been able to fix it. If it was to somebody else, we'll get them to transfer it back and disclose that happened. But it's still, but now it's at least back in the client's name. Maybe some problems with discharge under 727, but at least it's back and it's an exempt asset again before we file. But how are you going to do that when you got a minor child? You got to get a chancellor's, approval to transfer that property that now belongs to a minor child out of his name back into the dad without any money being paid to that kid.
And that's a red flag. And if I'm the creditor, under Mississippi law, that's a transaction that's presumed fraudulent that has to be taken, proven by clear and convincing evidence, overcome. And if I'm the creditor's attorney, I'm saying where there's smoke, there's fire. All right, go ahead. Let's go on.
We're on now chapter 7, fresh start. Of course, the chapter 7 is what I say that provision in the Bible says that debtors should be forgiven their debts every 7 years in the Old Testament. I've always thought that's why it's called chapter 7. But anyway, I've got a friend who's a member of the National Association of Consumer Bankruptcy Attorneys, and we spoke on the same panel before out in San Antonio one time and once in Vegas, and he keeps the Bible on his desk, for that reason. He says that's my reminder that's chapter 7. But in the 7, this is where somebody can get a fresh start, wipe out their debt. It's the best, and strangely enough, the fastest way for somebody to repair their credit. And people come in and they'll say, well, I don't want to do a bankruptcy, but I think I'm going to have to, but I don't want to ruin my credit. And I'll pull their credit report and I'll look at it. I don't get a score, I just get the report. But I can look at it and tell they probably got a 500 credit score right now anyway. And they got loans from finance companies and this kind of stuff. So one of the things that I try to teach my clients, the ones that I feel like have the capability to understand it, is how to rebuild credit afterwards and how not to have to ever come to use me again. And the thing they don't understand is when you borrow money from Tower Loan, First Heritage, First Franklin, one of these finance companies, it brings your credit score down. Because the computer at the credit bureau is programmed to believe if you borrow money from a finance company, you can't borrow money from the bank. Then they get caught in the trap of borrowing money from a finance company, they can't pay it, and they get these cards every 2 or 3 months from Tower or First Heritage saying, hey, you got great credit with us, come in and get another $500.
Or a check. Everybody got a check before?
Yeah. And they come in and they get more money and they get a new one. Well, you have to be in a loan for 6 months before it can be used to bring your score up at all. But in 3 months, they've gone and redone that. Now they got 2 loans from a finance company. And they do it again in 3 more months. Now they got 3. So they keep bringing their score down, down, down without ever bringing it up. So if they learn how to do it, and I teach them how to get loans from banks, and even though they've been out of bankruptcy and build their credit back, if they do it right, then they can, within 2 years, have a credit score in the high 600s after they come out. In 3 years, they can be over 700. I've got a friend that's a car salesman here in town that filed bankruptcy long before I got here, but I've become friends with him, and I asked him not this past summer, the summer before, said, how long has it been since you've been out of bankruptcy? And he said 7 years. And he and I both know that it's going to be on his credit report for 10 years. I said, what's your credit score now? And he looked at me, he just kind of smiled. He said, it's over 800. So bankruptcy can be used to repair and rebuild if it's done right. And the 7 is the best way to do that because you're in and out of your bankruptcy in 4 months.
All right, and debtors, if I'm on the creditor's side, if I'm the creditor's side, debtor, and I have the house, I have a secured property, a car, or something like that, a lot of times the debtor can pick and choose as long as he's going to keep current. He can reaffirm that obligation to me, and then a lot of times it allows him to get rid of, credit card type obligations. So, go ahead.
That's it, I think, on 7 with the amount of time we got.
And then we talked about child support and wrongful acts, and may not discharge student loans except in cases of extreme hardship. And I only seen that where somebody's just really disabled.
Yeah, I'll do 1 or 2 of those a year, but it's always usually, like he said, disabled, or one guy didn't finish and he was working for a sheriff and he would not, a co-deputy had beat the heck out of somebody and he wouldn't stand by him and stick up for him because he thought what he did was wrong. So he's now blackballed among all the police departments and sheriff departments in the state, so he can't get a job. And so we're able to show that he's, 3 things you got to show is that you made a good faith effort to pay under what's a case called Henry Bruner out of New York that everybody's followed. You can't pay it now and you're not likely to ever be able to pay it. And we ended up getting a settlement reducing it drastically. So what it was paying $400 for this student loan, he's now paying $150, and where it was paying $350 on this one, he's now paying $125, and got the rate lowered and the amount lowered and stretched out so he could survive. So to get a straight wipeout, it's just about like you said, got to be disabled.
Or be Gaines Banker.
Yeah, or have a picture of some catfish.
All right, chapter 13, which is a individual plan. Go ahead.
Okay. 13, when I was on the coast before Katrina and before the economy crashed, in Mississippi we did about 60 to 70% chapter 7s, and about, of course, the rest of that was 13s, somewhere between 30 and 40% 13s, depending upon what part of the state you're in. Since the economy's gone down, the 13s have gone up, and I would think that the credit card industry thinks that's because of that SEPA, which was passed in 2005, but in reality it has nothing to do with that, because I would say 1 in 25 people that could have qualified for a Chapter 37 under the old law might not be able to qualify for a 7 under the new law. So that's a very minimal reason. The real reason is they can't afford the car payments and their house note and the other things they got that are secured because their their income has gone down so badly. I mean, I've got clients that wife and husband were both making $100 grand a year, and one of them's lost their job, now they're making 30. Okay? And the other one, fortunately, is still up there. I've got a lady just called me today that was making $60,000 a year. Right now she's making $235 a week on unemployment. Okay? So, and some of these people, the only way they can keep that car is to take that $400 car note and turn it into a $250 car note. You can't do that in a 7, but you can do that in a 13 by reorganizing, changing the interest rate in some cases. If the car's old enough, they've owned it long enough, or if it's not a purchase money, that lowered and paying only value. So, and put it all into one plan payment where it comes out of the pay and they never see the money. And that way, if they don't see the money, they get it paid, and they're going to find enough money to pay the utilities and buy the food so that we can put your house. The house note doesn't really change, but we pay it through the plan. So they're able to come out of this with everything paid for except their future house notes.
Yeah, where I'm coming from with the creditor, if I got a house note or security, you can't cram that down. The debtor just has to pay it, and if he wants to stay in the house. I did have a government attorney saying something, well, why don't you renegotiate that note, give us a lower rate and give us a moratorium. And I said, well, the FHA does that, but I'm in a private, and that's the problem with the government getting into it, And the car, what they can do I'm talking valuation vehicles, the valuation of that collateral. If I'm undersecured, if it's underwater, then I got to give him. That's the argument that we will have. So.
Yeah, I don't know how he does it, but he only picks banks that do a real good job of making sure they're always oversecured.
Yeah. Well,
so I don't do nearly as well against his clients, and I don't know whether Hale is the one that taught them that, or whether they just were good at it anyway. But
yeah, I don't say that. They tried the argument. Oh, y'all don't want that house. They don't. but I don't say we have a 30% margin
Yeah.
to work with. I mean, good banking has always been good banking. You know, all right, talking about security issue. Go ahead.
One other thing about 13s, the biggest mistake I find that lawyers that do try to practice a little bit of bankruptcy and is that they only do 7s because 7s are easy and 13s are much more complex and hard, and they don't want to do anything hard. And besides, they're also doing divorce or personal injury or criminal cases, and they can't stay on top of the law, which I think is a mistake to try to do more than 1 or 2 areas these days anyway. But if they don't do that, they don't know when they can help a debtor, for example, with taxes in a Chapter 13. The taxes may be non-dischargeable, but you can stop the interest from running, and you can discharge the penalties, and you can lower that payment on the IRS or the State Tax Commission and spread it out over 3 to 5 years. And like I said, the interest stops on the date of filing. Okay, so they don't understand that maybe, or they don't understand how we can cram down. And I'll see people that were in 7s, they've gotten their discharge, and now you can't get a discharge in a 13 for 4 more years, and they really should have been in a 13 to start with. For 2 reasons. 1, they didn't understand it, and 2, it's kind of hard to be fair to your client and not kind of be blinded. It's kind of like the neurosurgeon is always going to think, not just for financial reasons, but because that's what he does, that cutting on that neck, or the orthopedic surgeon cutting on the back is the way to do it. Where a neurologist that looks at it, let's try to send you to the physical therapist, to the pain management doctor, to the neurosurgeon. Neurologist is out there looking at all these options and is going to try to steer them more, because he's not doing the surgery all the time. And some of these surgeons, like I said, it's not just money. It could be part of it, but it's that they believe in what they do. And so the guy that only does 7s is going to steer his client wrong a lot of times just because he doesn't understand it. And since he does it, he believes it. He thinks that's, or she thinks that's the way to go.
Well, one of the reasons I send clients, people who call, a lot of reasons you can't do both is you're going to be conflicted out. If you do regular creditors work. And so I'll send them to Robert because he actually does credit counseling. And he really gets involved in the financial issues that led to the bankruptcy in the first place. Instead of, there's some people who just file, and I said, what do you mean you filed to get out of a $4,000 debt and screwed up your credit? You know, I mean, you didn't call us and all that, but that attorney just took that fee and filed it. And so you can people are in dire straits or don't know where to turn. And so as an attorney, you can really get involved and help them and change the way they look at credit responsibly.
This is my favorite bankruptcy because of the thing dear to my heart. That's called attorney's fees, and because
but I get to object to it.
Yeah,
I get to look at his fees and say, I don't know about this here.
That is the hassle about Chapter 11s. You get a retainer.
Everything's transparent.
You get a retainer, and you get a nice retainer, but you not only have to submit a bill to your client, but to every debtor, every creditor and creditor's lawyer, to the United States trustee, and to the bankruptcy judge, who can always object. And even in 13s, if you go over what we call the presumptive fee right now, which is $3,000, if you go past that, you got to do that in time.
And I can also say, what has he done for the creditors?
Yeah.
Except collect a fee. He's got to do something constructive, right?
Yeah,
I can sit back and start saying, well, he's just, so it's very pragmatic that way too.
It is, but there is still a lot more money in a Chapter 11 if you get the right Chapter 11. It's also very complex, and most folks that try an 11 just because they've been doing 13s for 7 end up calling me and saying, I'm never going to do another 11. I'll refer all of them to you from now on. So you really got to be good with numbers. And the biggest mistake I made in law school was not taking bankruptcy. Okay, and the reason is because first we had 60 hours that were required back then because had the bar privilege. I always thought it was we were
You had
smarter. Yeah, I did. Yeah. He wasn't nearly as smart as his group. But I thought it was because we were smarter, but I realized later it's because that old case out of, I think, Washington said that.
You know what happened? The folks at MC wanted the bar privilege, and the Ole Miss said,
No.
we're smarter than you. We don't need a bar privilege. Thank you very much.
Right. But anyway,
I was the second year to take it.
so, well, I was one of the, yeah, I wasn't
And
that
I'm
far ahead,
biased.
but I was one of the last few that didn't have to take it. I
I'm
was happy.
biased for Ole Miss over MC.
But back to the 11s. Where were we when I got off that subject?
I did that to you.
Yeah.
A complicated, you know.
Well,
Let's talk.
Better move
Oh,
on.
I'm sorry, I did it again. Well, y'all can read that. All right.
Oh, I was going to tell you what. Math. I have a Bachelor of Science in Mathematics from this institution. Started college in '67 with a guy named Archie Banning. Y'all may have heard of him. And 10 years later, I finally got my law degree. I tell everybody, if you can't take a 7-year program and cram it into 10 years, you just didn't know how to have a good time at Ole Miss. But having a mathematics degree, 42 semester hours from calculus up, math is what I needed to do. And I made a big mistake not really gravitating to that initially. I should have only been interested in one or two things, either tax or that. So if you are considering bankruptcy and you've got a math background, either accounting, engineering, mathematics, or whatever, if you've got some type of math background, bankruptcy is a good place to look at. If you've got problems with numbers, you want to take this course just so you'll know when to bring the bankruptcy lawyer in, but you might want to stay away from it, because if it is, when you're dealing with 13s and 11s, it's number and finance intensive. So,
Well, I majored in history.
yeah.
But
But he doesn't have to worry. All he's got to do is pick my numbers apart. He doesn't have to try to make them right.
yeah. I have to show you where they're wrong.
Right.
But I went to Ole Miss when, you know, they wouldn't let you take a business course if you were a liberal arts major. All right. One thing about Chapter 11, the company does have to have some cash flow and ultimately come up with some idea how it's going to get out. And you generally have to keep, it's let's make a deal. And it's usually let's make a deal with the secured creditor, the one that has the lien on your property. And I deal with, one of the issues in a recession is my client doesn't want to take too much of the cash flow of that company so they can't do business and you know, pay their employees and pay themselves. So you have to wonder how much they can afford to actually pay your client, so they keep going as a going concern. So
We're almost at our stopping point. I want to tell you about Boudreaux and Thibodeau before you leave.
all right, wait, let's
Okay.
see. All right, there's Chapter 12, Family Farmer, and I think we've covered a lot of this. Okay.
Yeah.
He's got to tell his joke.
Okay. The bankruptcy code's a lot like a giant jigsaw puzzle, and because you got to learn every section in the United States Code refers to 2 or 3 other sections, and it's just like layers and layers, and so you got to really deal with that. And that always reminded me about when Boudreaux got himself a jigsaw puzzle. Y'all may know those jigsaw puzzles and get in the store. You know, he got one that had 24 pieces, and he worked on it the first day, and he got 3 pieces put together. He worked on it again the next day and the next day, and 2 weeks go by. Boudreaux, he got the whole puzzle put together, called his good friend Thibodeau and said, Thibodeau, you're not going to believe this now. Got me 24-piece jigsaw puzzle, put it together in only 3 weeks. Thibodeau said, yeah, Boudreaux. He said, but is that good? Boudreaux says, good. On the box it says 2 to 4 years.
John, any quick questions? I didn't have bankruptcy either. I had a client that came in my door with a Chapter 11 and needed my help. And so I got a whole set of Collier and learned it on the job so, I mean, you gotta, John Sarnansky is a great teacher. Y'all might have had him. and he's well respected in this field, so it's a good class to take. Thanks.
Yes.
Oh, sorry.
Do you do as far as like when, I guess I'm talking about secure transactions class, when, we were reading about cases about, contracts being put together as far as, how to be the trustee and not even get into the whole bankruptcy, trouble or lawsuit. Do you put that stuff together for the banks initially, or is that somebody like an in-house counsel bank person?
Banks tend to use national type forms.
Oh, okay.
I do that for businesses, anticipating what, if this guy can't pay, what is gonna, how can my client be protected? That's a lot of what I'm doing. How can I go and make sure he hadn't sold out all his inventory? And so if I know bankruptcy, I assume what the bankruptcy court gonna do in light of their deal.
Example of that would be Walter Mortgage Company. Y'all know what Jim Walter Homes are. Walter Mortgage Company uses their own form for a deed of trust. Everybody else uses basically the standard FHA form and on the deed of trust. And the law was changed in 92 or 94, I think October 92 or 94, that said that on mortgage arrears, you can't charge interest on that you're paying through a bankruptcy plan, 13 or whatever, unless the contract called for it. Well, so since the banks are stuck using the FHA forms, if the national group doesn't change that form, they're still not getting it after all these years, almost 20 years. On the other hand, right away, Walter Mortgage Company changed theirs to put a provision in there that they were going to collect interest on mortgage arrears. So when we file a Chapter 13, we're paying their mortgage through the plan. We're having to pay interest on theirs because they were able to do exactly what you said.
Or if you know how future advances are treated, additional monies or different loans, if the institution has different loans, if I can grab those pieces of credit, a security for different loans, and I understand how the bankruptcy court is going to treat those, I can frame my documents with the bank. Oftentimes, though, the problem, I don't really do a lot of consumer. I deal with the problems that, where people kind of go, this is difficult. And so that's kind of where I don't do kind of the run of the mill. I kind of price myself out of doing a lot of the finance. Intentionally.
Unfortunately, there's lots more you guys have to tell us, but this has to end.
Okay.
It's coming in about 5 minutes, but it's great to get an overview and also just to see the collegiality between attorneys that sit on different sides of the table. That's not necessarily something we get taught in law school. So please join me in thanking our speakers. Just a minute outside. I bet you guys will be.
Yeah, he even bought me lunch. You're welcome. Pleasure. Sure. I've been rolled. I haven't